Welcome back to Indiana News Desk. Well, many cities in Indiana are passing human rights ordinances that protect gender identity and sexual orientation in the wake of RFRA. Bloomington, Columbus, and Indianapolis have all passed such ordinances. And since then, a lawsuit was filed to challenge these ordinances. Joining us now to help understand the complaint and its goals is Professor Daniel Conkle of the Maurer School of Law at Indiana University. Thank you once again for being here.
Glad to be here, Joe.
So what is this lawsuit trying to accomplish?
Well, it's incredibly complicated and somewhat convoluted. Essentially, we had the Indiana legislature last spring pass the original Indiana Religious Freedom Restoration Act, which provided a general standard to protect religious freedom. We all remember there was a huge firestorm by critics believing that it might be used improperly to justify discrimination, especially against gays, lesbians, transgender people. And in reaction to that, the legislature did not repeal RFRA. It remains on the books to protect religious freedom in various settings, but the legislature enacted the so-called fix, which excluded from RFRA and the protection of RFRA most anti-discrimination claims, including claims by folks who claim they have been discriminated against based on gender identity or sexual orientation. This lawsuit came in response to the fix. It was originally filed back in December, and it was against Carmel and Indianapolis, and then Columbus and Bloomington were added in January. The lawsuit is brought by 3 conservative nonprofit groups, basically contending that the fix itself is unconstitutional because it's discriminating in favor of certain religious claims over others, and as a result, the original RFRA is still in place, and under the original RFRA, the local ordinances violate the original RFRA and therefore cannot be enforced against this group. So it's an incredibly convoluted lawsuit.
So I've talked with the mayors of Bloomington and Columbus. Both stand behind their ordinance, and they don't seem concerned at all about this lawsuit. Do you think that that's a good reaction for them to have?
Well, I think the lawsuit is unlikely to succeed, essentially because legislatures have and must have broad discretion in crafting religious freedom law, exemption laws, permitting religious exemptions in some cases but not others. That being said, stranger things have happened, and this lawsuit is being brought by a lawyer, James Bopp, who is extremely prominent, has succeeded, has argued cases in the U.S. Supreme Court. So it's not a frivolous case. I think it's unlikely to succeed. More to the point, there will be a hearing next week in the state court that is considering this case, dealing with a number of procedural issues that might prevent the lawsuit ever from being heard on its merits.
So in just 30 seconds, if this case is dismissed or doesn't go anywhere, do you expect that to kind of be the end all?
I think if the case is dismissed on procedural grounds, then I think it's highly likely that the challengers will appeal on those procedural grounds, taking it up at least to the Indiana Court of Appeals. And whether they would try to take it further, I think remains to be seen. If the case is not dismissed, it will go forward, and the court will then have to resolve the case on its merits.
All right, thank you. We'll keep an eye on it, and we have to end it right there. Thank you very much.
You're welcome.